Good morning, afternoon, evening, midnight, or noon. I'm William Espy, and today we're talking about U.S. law and AI. Now, if you haven't noticed, AI has been one of the greatest growing industries in the whole world right now. Currently, ever since the release of ChatGPT, AI has basically just taken over the world, really. It's probably going to create Skynet and maybe murder us all, but that'll be fine. But until that day comes, we will try and regulate it as best we can, and that is where U.S. law comes in. Today we're going to be talking about how the U.S. law has had to necessarily morph itself, change, and look at previous precedents to find a path forward in this unprecedented time, really. So, let us start. U.S. law and AI. So, the first subject we will be covering today is copyright. So, before we even get to AI, we're going to start all the way back in 2011. Now, in 2011, there was a little guy called a monkey. His name was Naruto. And you see, this little itty-bitty monkey decided to take a photo of itself. Now, this photo was placed by the photographer David Slater. Now, Slater later did use that photograph, but in 2016, 5 years later, the People for the Ethical Treatment of Animals, or PETA, sued him, claiming that the monkey, Naruto, actually owned the image. Now this went to the Ninth Circuit Court, which is wild, and the Ninth Circuit said, quote, "We conclude that this monkey, and all animals, since they are not human, lack statutory standing under the Copyright Act." Basically saying that, no PETA, this monkey cannot sue for copyright. And this, of course, set the precedent that only humans can get copyright, which, well, makes sense. So, continuing with copyright, our next interesting event actually has something to do with AI. This is Zyre of the Dawn. It's a comic book series written by a Miss Christina Castanova, which, although Christina did write the script, and she did add the text to the comic book, the images themselves in the comic book were made by an AI called Midjourney. Now, Casanova originally did get approved for the whole comic book by the Copyright Office, but later the Copyright Office reneged on this, saying that Casanova, although she did own the comic book as a whole, the images in said comic book were not able to be copyrighted by her because they'd been made by the AI. So the arrangement of the images and the text were hers. The actual images made were uncopyrightable. And notably, the Copyright Office actually used Naruto v. Slater for their decision for this, and they cited it for their decision. It is a very interesting thing how a precedent from a monkey goes onto precedent for the future of AI. Yeah. So, for our next copyright case, we're going to be talking about Thaler v. Perlmutter. Now, in this case, Stephen Thaler actually made an AI model for image making. Now, he tried to get the image, which was made by it, in this case, this beautiful thing on the screen, by the Copyright Office, but he was denied. Now, the Copyright Office, again, used the precedent that only human works can be copyrighted. Now, this went to the D.C. Circuit Courts, who upheld the copyright decision, and then went to the D.C. Court of Appeals, who also upheld the Copyright Office's decision. So, all these three cases, what have they said for AI? The effect? AI works cannot be copyrighted because they are not made by humans. This is going to be a pretty big deal. Well, it already is right now, but probably in like 15 years or something, this is going to be a massive deal for people using AI to make images. Like, I don't know, like half the slides in this video, but we'll worry about that later. But this also opens up something else. What about data use? So, for data use, we have the case of Thomas Reuters versus Ross Intelligence, Inc. Now, Ross Intelligence built a AI legal research assistant with headnotes made by Westlaw, which is a legal research program, without consent from Westlaw. In fact, Ross actually asked Thomas Reuters, the owner of Westlaw, to license their headnotes, but Reuters declined the offer entirely. Ross Intelligence then went to a legal analytics company called Legal Ease and wanted to use Legal Ease's bulk memos, which are just a collection of good and bad legal questions, and with corresponding good and bad answers. Now, these bulk memos actually contained Westlaw's headnotes, though they technically weren't supposed to be there. Ross got permission from Legal Ease to use these headnotes, and used them to train their AI legal research assistant. Ritter then sued Ross Intelligence for using the copyrighted material without permission. Now, Ross Intelligence did claim fair use, and originally, the District Court of Delaware did in fact side with Ross. Now, later on, however, they re-reviewed the case and found that Ritter's claim was actually valid, and that Ross had actually used the copyrighted material illegally. Now, this came down to one very big thing. The AI legal research assistant made by Ross Intelligence was, in fact, a non-generative AI, meaning that it didn't actually create new content from old stuff, like the ChatGPT reference I made before. It only took old stuff and gave it to people, giving them exactly what they wanted. It didn't make brand new cases or use previous evidence to create brand new documents. And for that reason, they found that the use by Ross Intelligence of the headnotes was invalid. They couldn't use it, and it was not protected by fair use. So, for data use, we have the New York Times versus OpenAI. Now, this is a very recent case, and it's pretty famous right now. And the basic idea is that if you went into ChatGPT and asked it to summarize a New York Times article, it actually give you that New York Times article almost verbatim from the article, which is acting as a market replacement almost for the New York Times, since, well, you don't actually need to get a New York Times description to read their content. Additionally, this infers that ChatGPT is using New York Times works to train their language model without permission. Now, this is a very big deal. And in 2023, New York Times sued OpenAI for that exact thing, being a market replacement and also using their works without permission. Now, notably, ChatGPT is generative, meaning that although it can give you verbatim works, it can also give you brand new stuff and summaries and stuff like that. Now, this is still in the courts, so we will not get a decision probably for a while, though probably not too long. And this is going to be a very big deal when it comes out, because this is going to probably set a precedent for the next 20 or 30 years for whether or not generative AIs can be trained with unlicensed material. And I will probably cover this when the decision comes out, because it's going to be very important. So, overall, what is going on with data use for AI? Well, 1. You cannot use unlicensed material to train a non-generative AI. You just can't. But, in the future, we may see this either apply or not apply to generative AIs, because, well, it's creating new content. It's maybe transformative, or maybe it's not. Who knows? We'll have to see in probably a year or two when the courts finally come out with some more decisions on these cases. But until then, I'm William Espy. This is Precedent in Motion. And good morning, evening, afternoon, noon, or good night. Thank you for watching.